This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Good afternoon, everyone. Thank you for joining us today for our program on Legends of the Law Part 2, Learn from the Pros. My name is Hayward Cho, and I'm the General Manager of ADR Services, Inc. I'm going to turn it over to our moderator, Stacie Hausner. We are so proud to have her on our panel at ADR Services, Inc. She has mediated more than 1,000 disputes in all areas of the law. She has taught more than 30 mediation classes at Pepperdine Law School as an adjunct faculty member, and trains many of the lawyers and judges who become mediators in the industry. So without any further delay, let's get to this. Stacie, take it away.
All right. Well, thank you, Hayward, and thank you all for joining us here today. I am very pleased and honored to be moderating this panel of amazing attorneys. The very large turnout today, I think we have 830 people registered, is really a testament to the incredible careers and reputations of the lawyers on the panel. So thank you, panelists, for sharing your lunch hour with us. I know Genie and Bernard are coming in from court. Bernard's actually in trial right now. And thank you for sharing your insights regarding our profession. Each one of these lawyers has accomplished an incredible amount during their extensive legal careers. Each has received numerous awards, chaired many of the legal organizations, and collectively they've tried hundreds and hundreds of cases. They are all so humble that they asked me to forego formal introductions, and that's probably a good thing because I think it would eat up much of the time we have here today. So let's jump right in to hear legal advice from our panelists. I want to start by asking each panelist an opening question before engaging in a roundtable discussion. So my opening question is this. Each of you has had an extensive legal career filled with lessons learned the hard way and others learned the easy way. What is the most important lesson you have learned and how did you learn it? And let's get started with you, Brian, if that's okay.
Well, there's so many lessons that I've learned. Every day I learn a new lesson. I think the most important thing I learned is to exhibit civility in how you deal with the court and other lawyers. And I think as a young lawyer, you maybe don't have the confidence and maybe being a little more aggressive. You think that's the way to do it. But at the end of the day, getting along makes it a lot easier to litigate, to settle, or to try your case. So I would say that's the biggest lesson that I've learned. Coming from a background that is more physical in nature and the law is completely different, and you got to get along and not attack the other people.
I appreciate that. Thank you, Brian. All right, Patty.
I before I ever get to the stage where you treat people civilly, which of course is important, both opposing counsel and the court, and frankly, all the court personnel. The things that I learned the most is nothing replaces hard work. If you assume a certain level of competency, expectation of yourself as well as your opposing counsel, that just is assumed. What the critical thing to me is hard work, and don't imitate. Pick up lessons from the people who are senior to you. Watch them and don't imitate them, because you have to adapt to your own personality. Be yourself, and everything else will come. But don't ignore the lessons you can learn from people who have been doing this for a long time.
All right. Thank you, Patty. I appreciate that. Okay, Bernard.
I would say humility. In the type of work that we do, we constantly have wins and we get big settlements with that. And I think being able to keep things in context and appreciate that regardless, even though you've won trials before, You start from scratch. You still got to put the work in, even though you've had successes. You still got to be able to listen to the person on the other side, because they could be right, or you can figure out what disagreements you have. So if you come to things with a sense of humility, a sense of this other person is trying to achieve something the same way I am, and have a conversation and make a connection, I think that goes a long ways. Goes a long way with a judge that you don't know, goes a long way with jurors you don't know, goes a long way with attorneys that you meet for the first time, or going to have a long-term relationship with if you stay in the law for a while.
Thank you. Thank you. And last but certainly not least, Genie.
In addition to all of the things that these incredible colleagues have said, which are all 100% correct, I would say it's incredibly important as well to persevere. Like, this job is hard and we get things right and we get things wrong, and we make mistakes often, whether it's simply, starting off on the wrong foot with opposing counsel, or if you misstate something in court. I think it's really important to persevere, remain calm, admit if you got something wrong, don't get defensive, and just try to stay steady as she goes along the way. This is a very long career. I liken it to a never-ending marathon with innumerable individual sprints. That's what we're doing here. And the fact is that we just need to continue along every day. And hopefully what's happening is that you're doing work, we're doing work about which we're passionate. That's where our energy comes from. So be passionate about the work that you do and persevere, because in the end, if you're civil, professional, if you work hard, if you prepare, it's going to be okay in the long run.
All right. Well, thank you all for that. Thank you so much. Okay, so let's begin now our roundtable discussion on a few topics. I will start with the topic near and dear to my heart, and that is mediation. So we know that about 95% of all cases settle. So it's important for lawyers to be thinking about settlement as they are preparing their cases for trial. What advice can you give to lawyers to optimize their outcomes at mediation or during settlement discussions? And let's start this time with Genie.
Well, I think it's incredibly important to make sure that you really understand the story of the case. And that means getting together with your client, doing so in their own home setting, whether it's a personal injury case, an employment case, and really walking through understanding all of the events thoroughly and almost in a first-person way as much as possible. And then telling the story in as complete a way as one possibly can, including using demonstratives that you can put together for mediation, whether they're videos, whether it's testimony from witnesses, declarations, that kind of thing. That can be incredibly persuasive. And one of the things that I like to do is I like to use videos in mediation to tell my client's story, because I want to be able to go into the other room. I want to be able to go into the room with the defense and have them listen to the way and watch the way that I prepared and framed the case, but not be in their faces, so to speak, so that my presence isn't in the room. It's just there on a video. And I think that can be very helpful. And I think you really have to prepare your client to be able to converse with the mediator. That's my personal opinion. I want the mediator to see that my client's going to be able to testify and testify well. So those are a couple pointers.
I like it. Anybody else want to jump in here?
I do. I want to just say that mediation is a strange little animal today, much stranger than it used to be, in the sense that there are different points in time in litigation today where I use a mediator. I frequently use a mediator before the case has been filed. I frequently use a mediator right after a case is filed. And then the other time is after a large part of discovery is done. and you actually know good news and bad news. I agree with Genie. I think people really are much too casual frequently about mediations, because I do think a presentation, including graphics, whether it's a video or whatever, is an important tool, because I treat it as if I were making an opening statement at a trial. And the final thing that I think is probably self-evident, it really does matter who the mediator is for a particular kind of case. ADR has some good mediators, signature jams, they all have good mediators. But you need, and that's one of the things that experience brings, I think, is that you need somebody who depends on the case. Maybe somebody, you don't need to be the brightest guy on the panel. Maybe you need somebody hugely smart. Maybe you need somebody who's good with insurance companies. Whatever those qualities are, it's critical to get the right mediator.
I'm gonna add to that. I agree. You need to pick the right mediator for the case, and it might be you need someone who's going to be sympathetic with your client because your client is not good with confrontation, or maybe you need someone to be the voice in the other room to the decision maker. Decision maker has their own peculiarities, and so you find a mediator that can break through that if it's a breakthrough or converse. So always got to have the right mediator. For me, particularly on the plaintiff's side, I think it's important to value the case before you get there. Some mediators and some people will say, well, that's a lot of money for the client. And that I find often offensive, because it basically means that if you're a doctor or a lawyer or an engineer, because your salary is a certain number, then you get a certain value. But the truth is, some incidents, some things that happen in a person's life, it has an inherent value. And so you have to figure out that value before you arrive there, because you don't want to be impressed by the number. That number, it might be big, but if it's not the value of the case, you got to be armed to tell the mediator why and be able to hold your guns. The other thing is to listen. If you've really prepared for the mediation, it's a lot easier to listen to the other people on the other side, because then you can hear them when they're saying something that makes sense, that tells you, oh, I've overvalued the case. It isn't as though we're perfect. You have to go in with I think, a sense of what the value is and why. That way you can listen to the other side and explain to them why they're wrong, or explain why they're in the wrong range. Seems to me that mediation is a good vehicle as long as you understand or have an approach to how to do it. And then the final thing I'd say is the mediation process doesn't start when the mediation starts. It actually starts before. Conversations you have with the opposing counsel to tell them, hey, this is the range that we're in. If you aren't in that range, let's not waste anyone's time. And then when we get there, if they waste their time, then you slam the door and you say, that's it. So the conversations you have before the mediation gets started, that's how you make sure you have a success. You do the 998s early. You do a 998, you let it expire. That sets a floor. There are things that you can do to kind of frame the mediation before you get there to make sure that you're in the range that you think the case should be in.
Okay, so to summarize, I would agree with Patty, very specific selection of the mediator. The selection of the mediator is the most important thing. And you want a case-specific person. Whatever Patty said, insurance, dealt with this defense counsel, things like that, that to your case, they're going to help you get there. Number two, lawyers file too big of briefs for mediation. They want to put in every piece of evidence. They want to attach all these exhibits, and it's 2-3 inches thick. You should be able, in 5 pages or less, put forth your case. You should also, what we do is provide an executive summary. Plaintiff claims for damages A, B, C, defense claims this, plaintiff's claim on theory this, defense claims this, and on 1 page, you have the case. And that's what it's really going to come down to. I think the third thing that, for me, I think is critical is to prepare the client before the mediation. You have to take this very seriously, as someone else said. You have to deal with your client's expectations, especially as a plaintiff lawyer, but sometimes also as a defense lawyer. And you have to have parameters before you go into the mediation. You have to be flexible. You have to listen, because you're going to learn a lot of things, and they're going to want to tell you the other side why your case is not worth what you think it is. And I think it's important to share the briefs with the other side. I mean, if you're in there hiding stuff, you want to go to trial, fine, you don't need to go to mediation. But if you're in mediation, you should give it a good faith shot. should take it seriously. And as Bernard said, if you're in a range and they, your range is 1 to 3 and they come in with 0.2, then you're probably not going to go anywhere. But that's preparation ahead of time. So that's what I would say.
If I just follow up with one thing that Brian said, we often share our brief because we've got the burden of proof. It doesn't do any good for us to hide the ball. And if we're going to really try and settle, we got to be willing to throw it out there, even though there might be consequences. I might not throw everything out there, but certainly the reasons why I think there's liability and the reason I think the value of the case, that's going to be in there because there's no chance they're going to get the numbers I'm looking for unless I'm able to persuade them as to the why.
And I will tell you, Bernard, in response to that I think not only is it, I handle a lot of complex business litigation, and it is such a waste of money to not share briefs so that the first half day is nothing more than a very high-priced, expensive messenger going back and forth when that's just a waste. If you have things that you want to hold back, I totally get it, and you put those in a little pocket brief and just show the mediator. But don't. I really, really can't say this strongly enough. Please share the mediation briefs. It's just a tremendous waste of money and time for your clients and yourself.
Totally agree, Patty.
I totally agree with that too. This has been great advice on mediation. Thank you all for sharing that. All right, so I'm going to turn the topic a little to trial, and all of you are known for being fantastic trial lawyers. So I know that we can learn so much from you regarding trial tactics, from picking a jury all the way through getting a verdict in your favor. So I know this topic, you could all spend hours talking about, but if you were to briefly discuss, what trial advice do you have for the attorneys listening? And this time, let's start with Bernard.
I've created a trial college, and I brought some of the best attorneys in the state to teach. And the thought was, you don't have to create things from scratch. There's already a wheel out there that's been built. You need to see other people, read their transcripts, see how they do it, and figure out what things they do that you can incorporate into what you do. I can't be Brian Panish, but there's nobody that organizes the subject matter and lines it out for a jury better than Brian. If you don't have a way to do it, why not follow his way? Victor George, in terms of the way he tells a story, there are all these great attorneys out there. You go watch them try cases and you'll figure out how to do things right. You can always figure out a better way. You can always figure out your way. But in terms of figuring out a right way, a consistent way, there are attorneys out there that do a fantastic job of Nate Goldberg, storytelling. You look at those people, you read their transcripts, you can't help but learn how to do it right.
And I just put in 2 cents here. I am going up to 30,000 feet. Of course, I agree with what Bernard just said. Having said that, I actually think that the jury system is marvelous. It's magical. It is the only place in the world where we have people participating in democracy firsthand. It's how they touch democracy in a real way other than voting. And it gives people an opportunity to have a voice. Doesn't matter if I bring a rich client to the court or a poor client to court, they want to get to the right result. In my personal experience only, 99.9% of the time, juries get it right on liability. Where they get a little screwy sometimes is dollars, because, I mean, if you make $100,000 a year, as a juror, and you have a case where some of my cases are $100 million plus, I have a hard time counting that high. So I'm saying to you, I think if you approach a jury and the jury system as if you're in awe of it and want to be part of it, and therefore never condescending, never talk down to people ever, and embrace the system, because actually it's fun. Okay.
Yeah, it is. Stacie, can I jump in?
Yes, please do.
And we'll leave the big hitter to the end anyway there on this. But I really agree with Patty. And one of the things that I think about, and I tell less experienced lawyers to think about, is, treat people in trial, especially in front of the jury, and think about the jury as if they're guests in your home, and people you want to make feel comfortable, and you want to feel comfortable around them. Obviously, we're in an adversarial system, so things get heated and that kind of thing on cross, back and forth, blah, blah, blah. But if I just try to think about making sure that the jury is comfortable and helping them do their best job. And so that's one of the frameworks that I usually have in my mind, which has been beneficial to me. But also, I want to give a bit of a tip, especially to lawyers who don't try that many cases. I think it's incredibly important that you do mock trials, focus groups and mock trials before you go to trial. I think it's important. I always do them in my cases. But I think it's really important that you do so. It helps you figure out your case, learn how to frame your case in a way that hopefully is going to be receptive, that a jury is going to be receptive to. And it really just forces you to prep in a way that may not happen if you avoid doing that work.
Thank you for that.
Okay. My first trials that I did, I was at the dinner table, the oldest of 6 children, the son of a trial lawyer. So I got experience in it real quick. And what I learned is, number one, you got to have grit. You got to have passion and perseverance. It's hard. It's every day like cramming for finals, even though you're prepared before. Things change every day. Genie, I think, mentioned earlier about trying to stay even keel. I look at trials like a roller coaster. There's ups and there's downs all the time. You got to try to stay in the middle. I think being nice to the other counsel, look, we're trying to get money for our clients. We want to come across as nice and embracing with the other side. I think the story part that you talked about earlier is what the whole trial is about, telling the story and how do you do that. And one thing that a lot of people don't do, including in many openings, which are now being very chic or trendy here, is you don't embrace your weaknesses. And, you want to hide and think, oh, maybe they're not going to bring it up. Of course, they're going to bring it up. They're prepared. They know. So you need to see, what are my weaknesses in this case? How am I going to embrace them? What is my spin on them? And how am I going to inoculate the jury about these problems in my case right off the bat, whether it be in a mini opening statement? I see many lawyers, they win the case on their mini opening. Well, that's a bad mini opening. When you're mini opening, you need to give the worst part of your case to identify those jurors that are going to be bad for you. So the only reason I wanted to be a lawyer was to do trials. The rest of the job is not fun, depositions, summary judging, but the trials are fun. And my family always say, well, you're in a bad mood, go get in a trial. You're always nicer when you're in trial, which is counter to, I love it. I wake up every morning, I can't wait to go to the courthouse. I love driving to downtown or wherever the trial may be. So this is the best part about being a lawyer. What we do is going to court. It's a competition, but you're representing either side, a client, and it's a big deal to them. And you got to take it as a big deal, but it is the fun part of why we all do this.
There is nothing, I think you would agree with this, nothing more exciting than when the jury has let the judge know that they reached a verdict and you're sitting there with your client. And I'm talking about a lot of business executives, men and women, who are not prone to cry every day, who literally wait for the judge to look at that piece of paper to see what the verdict is, and it gets back, and then the jury is pulled. I've got to tell you, there's nothing, television and the movies don't begin to capture the emotion of that moment. And it's the payoff, at least in my experience.
And I would say, that's the hardest part of the trial for me, waiting for the jury. The verdict, it is what it is. But I think one lesson I learned as a young lawyer I was in a trial very young with this lawyer from my firm partner, Oklahoma, and we're driving home from court and we had a great day. And he says, you know, Brian, there's nothing better than driving back to the office, having a great day in court. He goes, but there's nothing worse than driving back to the office after you got your ass kicked or you had a bad day. So again, that roller coaster, you got to try to stay in the middle, because no trial is going to be perfect. There's going to be things you didn't expect. Things aren't going to go as well as you'd hoped, but you need to be able to adapt on the fly.
I want to just follow up with two things. One that Brian said, what Genie said, with regard to focus groups, the point is not to win. It's like when you do that mini opening, the point is not to win. With my focus groups, I don't always do them, but when I do, I take my best fact and I don't use it. And I try and win with the 4 bad facts, or the 4 good facts, or okay facts, or 3 okay facts. And I hope that the jury is going to tell me what's missing from my case, and I'm hoping it's going to be one of those things. But it's a bonus if it turns out to be, they tell me something that they'd like to see on my case that I didn't know about, that I didn't think about. The point to a focus group is really to lose and find out what you need to do to win. That's the way I treat focus groups, and I think that's the best way. Same thing with your mini opening. Boy, if you're giving them your best stuff, you're missing an opportunity, because the whole point is to tell the jurors the bad stuff, so those jurors, their eyes will open up and say, oh, I hate that. And you can get rid of them, because they aren't going to tell you. You got to deal with the body language to find out from them whether you really want to ding them.
Stacie, I just had one other point in the use of experts.
Yes, please, please.
I think jurors like to go home and tell their significant other, you know, they told me this is really complicated, but I understood it. It was clear to me. And the way you do that is I don't need the smartest. I don't need a law professor. I don't need somebody with 12 degrees. I need somebody who has testified before. So it's not their first rodeo. They look jurors in the eye and they take, not condescending again. They take difficult concepts and just make them easy to understand. That's what jurors, and then they feel so empowered and so good about frankly, the jury system generally, because they got it. So I urge people to really pick the expert witness or witnesses who can explain things in a very straightforward, not condescending, but straightforward manner.
Same thing for us as attorneys. I used to, when my son was like 4th, 5th grade, on the way to baseball practice or basketball practice, I had 3 different sons, so everybody got a shot at it. If I couldn't explain my story to my sons, I was failing. And they'd let me know. Well, do you have any more facts? And I'd give them another fact. You have more facts? And oh, well, if you tell the story just that way, well, that means I've got to figure out how to tell the story. If your 10, 12-year-old doesn't understand the story, you got to tell the story a different way.
This is great advice. It really is. And it's also supported by social science experiments. Say people like ideas and stories they can understand. So that whole simplify it so they can understand it. I love it. Let me ask you this, specifically with jury selection. Is there any advice you can give on what not to do or what to do? Because a lot of people say the case is won or lost at jury selection. Do you agree with that? And then what advice could you give in that regard?
I'll go first. Yeah, I think the case is won or lost in jury selection. I think the final argument is just for the lawyers. Maybe you're convincing a few people, giving them ammo to argue for you, but it's who's deciding the case. I think the number one thing for a lawyer to do is listen and not talk. Ask us short, open-ended questions. Let the jurors talk. Lawyers want to preach this concept of preconditioning. It doesn't work with jurors now. They get they have common sense. It's not working. The judge's not going to like it, and it's not worth it. You need to get on your core issues, and mine are usually, jury verdicts, lawsuits, money damages. I mean, that's my main areas that I'm for dire. And I'm looking for the people that are open-minded, that don't think there's too many lawsuits, that people are too ready to sue. The lawsuits are costing us all too much money. I ask that question, yes, no, maybe. Then I want to talk about jury verdicts. You believe jury verdicts are excessive? Yes, no, maybe. And just let it, and then say, oh, why do you say that? And so let the jurors talk. Lawyers like to preach and talk too much. Less is more. Jurors appreciate that. And just like in a trial, lawyers like do the same thing 10 times and the jurors are laughing like we already knew that 5 times ago. But the lawyers have some self-confidence they're lacking that they got to go over, multiple times. So
Yeah,
that's
Brian,
right.
Brian, one thing though that I think is worth mentioning, and everybody can disagree with me. There are some cases that we handle where you want to, there's some sensitive areas that you don't necessarily want to ask the question yourself. And most judges will, if you talk to them in advance, of course, will ask some of the tough questions that you don't want to appear to be a complete jerk asking yourself. And I can give you an example. We had a case where there was right after 9/11, where we represent somebody who was Persian, and the judge literally helped us by taking into chambers each person who raised their hand and said they had a problem with just my client, because my client was Persian. And we literally went into chambers and discussed each one, many of which were like ridiculous, but some of them were legitimate anecdotal experiences that they couldn't possibly render a fair verdict. But again, if there is a sensitive area, see if the judge he or she will help you asking those, what I call difficult, sensitive questions.
I think it's really important, again, keeping with the right mental framework to prepare yourself to really hear bad stuff in jury selection. But you want to find out for whom is this not the right case, right? And it's okay, and it's important to know that this is not the right case for, Ms. Doe or Mr. Roe. And don't become defensive and judgmental and argumentative when you hear the bad information. That's what you're actually trying to get. So think to yourself, thank you for that, and make people feel comfortable saying and talking about things that are not comfortable, and just be upfront about it. Say, we've got to have an open conversation about some really important issues. Nobody feels comfortable. A lot of people don't feel comfortable talking publicly. That's totally okay, but we have a job to do here together. And so I think if you set the groundwork and let people have a mental framework about what you're doing and why you're asking, for them to speak out loud, which obviously the judge is telling them they have to do, about sensitive things or, not so sensitive things. And then you're going to talk about more sensitive things in chambers, but just say, like, this is where we have to do this. This is the forum in which we have to do this. And we're all doing it together. And I think you begin to build a group dynamic, and it's really important not to be defensive. Stop arguing. The point here is not to try to convince people of your case in jury selection. From my perspective, I totally agree with Brian. It's about trying to figure out who is not the right person for this case. That's the most important job that I'm doing when I'm picking a jury.
So I'm going to add to Brian's list. Do you value emotional distress? And if so, will you award damages for it? That's where the value is at least the employment cases, the civil rights cases. In terms of the closing not being as important, I sure hope not, because I got a great closing coming, and I think I understand the case now. But in terms of picking the jury, you can't deselect, so you have to find jurors that are receptive. And so it does no good, regardless of how good your case is, if you don't have a receptive jury, then your case is not going to go anywhere. So the key is to find receptive jurors, and you aren't going to find jurors that favor your case necessarily. Just, that doesn't necessarily happen. You go to some jurisdictions, I'm going to say Riverside as an example, none of those people you would pick if you were here in downtown Los Angeles. But when you're wherever you are, that determines how you pick your jury. So you got to find people that are receptive, and you got to spend time to talk to them and try and draw out who they are. I think that, going to Patty's point, some judges are not good at voir dire. They go through the motions, but they don't do the follow-up, or they don't deal with sensitive issues, and they want to avoid them. And so you've got to be able to be the person to stand up in front of the jury and ask them those questions, and do it in a way that allows people to want to talk, and get other people talking. The way I know I've done a good voir dire is if I get different jurors talking to each other about an issue, because that's where I find out the information, not necessarily from the direct conversation, but the interactive conversation. So bottom line is, got to be able to get the jurors to talk. You can't be looking for jurors that are just on your side. You got to get them to be receptive. And I learn information from them so that I find someone who's experienced emotional stress, they've taken medication and done that. I mirror that with my clients. When my client is testifying, they're testifying to those jurors that said they've experienced emotional stress, or they have a sister or a brother that has, or something like that. Finding out information from the jurors is how you basically tell your story to individual jurors and echo your client's story inside the jury room when they get there.
Can I mention one more thing? And
Yes,
just
please.
again, to the type of cases that we handle, we use, if at all possible, jury questionnaires. I find them to be invaluable. Sometimes it's because some of the sensitive questions can be asked in a jury questionnaire, and it's coming from a neutral place. And I also think that they give you tremendous basic information to make the voir dire, the actual voir dire, much more meaningful and helpful in selecting a jury. I don't know if the selection of the jury is a be all and end all. I've seen juries change once they listen to the witnesses and listen to your opening and sometimes your closing. I'm not sure the closing is that significant, but I do believe the opening is significant, and I do believe a connection between the lawyer and the individual juror is critical. And you have to engage with them. You have to talk to them, not talk down to them, but talk to them.
Just on the jury questionnaire, it's critical if you can get it. The California Code said the judge should. Of course, they don't have to. The mini opening is supposed to be mandatory, but I've had judges say, no, you're not going to do it. If I don't like the judge to ask too many questions of mine unless I'm limited on time. If I'm limited on time, federal court, I got to limit it, or I got a judge that doesn't follow the rule that says you're not supposed to restrict time. Then I have a lot of basic stuff I let the judge ask. I always, at the very beginning, I always say, if there's anything that you want to discuss in private, you don't want to do it, it's no problem, please let us know. I do that right away. So then once in a while it happens and you go to chambers. Patty had a dicey issue there post 9/11 for sure. And I think some of the really hard questions, you got to ask them as the lawyer, and you got to be ready for the bad answers. But bad answers are good because you're finding out information. It's counterintuitive. You're not going to get everyone that's going to be perfect for your case. In state court, you only need 9. And there's a lot more maneuvering in state court with use of peremptories, and how you do it. Federal court is different. And finally, I find that it's very important to file a procket brief before the trial on cause challenges. The standard in California is that, you got to show that they're absolutely unbiased and all entire bias. And some judges say, well, they say they're going to be fair. They'll just jump in and they say, well, Miss Joy, I'll give you the law, you'll follow it, right? And you're going to be fair. And they go, that's it. Well, that's not it. And, you're going to get in a battle with the judge on that. But if they're following the code, it's show total impartiality. And some people, they're going to admit, I'm not totally impartial on this one issue. I'm not. Well, that would disqualify them from your case. Cause challenges is a whole art in of itself, but it's pretty important in a trial.
I'd like to have that brief, Brian. Maybe I can sneak it from you.
You got it, whatever you need. I also have, when I'm limited on time, judge, you have 30 minutes to pick the entire jury, alternates, everything. I have a board I use. I pick the 5 or 6 most important questions in the case. And there's one judge in downtown, I've had like 6 trials with him. he's always restricts the time, no matter what the code. That's just how he is. You can't argue with him. Every time I go on with a different lawyer, they keep arguing that point, and they're never going to win. I lost 3 times. I gave up. I knew he's not, this judge, who Patty knows well, is not going to change. But other than that, he's great, and he lets you try the case. So for him, I have 5 or 6 questions. He's even allowed me to put on a piece of paper, and it just goes, juror number 1, what's your answers? Yes, no, maybe, yes, this. All right. And then you could follow up on the one you want to know. But you got limited time. You got 4 or 5 issues, and that's a fast way to do it, and to pick a jury and to get valuable information.
All right, thank you all for that. I just want to switch our topic now, if I can, to arbitration. Some lawyers are happier in arbitration than others, obviously. How does your strategy differ when you are in an arbitration? What are you thinking about? What could you advise lawyers to do differently or not do differently? All right, and let me start with you, Genie.
I still think that storytelling is incredibly important in arbitration, even when the arbitrator's making the decisions. But even before that, you got to do your best to get a good arbitrator. That's the whole kit and caboodle right there. So if you've got an arbitrator who is not going to follow the law, you're going to be in big trouble. And there's not going to be much of anything that can be done about it. I think we all know, and some of us have been there. And so that's the real challenge at the beginning, is figuring out who's going to be your arbitrator. And it's just a really unfortunate process from my perspective. I am incredibly anti-arbitration. It has a terrible negative impact in employment cases. Even though the win rate is not necessarily substantially lower, the arbitration awards when the plaintiffs do win are minuscule in comparison to what a jury would award in the same kind of case. And that it is a travesty of justice from my perspective. So you just have to do the best you can, try to get a decent arbitrator, and you've still got to just swing for the fences in telling your best story. And you're going to hopefully be focused on, unfortunately, I hate the fact that this is the case, but you're going to also be focused on what the economic damages are in arbitration, because my experience has been that arbitrators are going to be more comfortable awarding the economic damages as opposed to substantial non-economic damages. I'm very happy that federally, we have a change with regard to sexual harassment cases, in part because of the Me Too movement and the Weinstein cases. When I would go and lobby in favor of the Fehr Act in DC, I would explain to the legislators that when my client, who was Harvey Weinstein's personal assistant, 25 years old, was handed an arbitration agreement to sign at the beginning of her employment, she had no idea that Harvey Weinstein had been raping women for going on a couple of decades, but the Weinstein Company did. And why did the Weinstein Company want that arbitration provision? Well, we all know why, because it was going to be, his conduct was going to be kept secret, and people like my client would not get a fair outcome in arbitration. So anyway, you push my button. I'll stop now.
No, it's great. It's great. All right. Who else wants to jump in on this?
I want to hear from Patty. I bet Patty's done more arbitrations than all of us in this room added up together. She's done the most I know.
I've done many, 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 and I don't necessarily agree with Genie because I think arbitrations, judges, I usually pick a retired judge, not somebody who's not. Number one, I think the selection of the arbitrator is everything. So Genie and I are definitely on the same page on that. I think you need to pick, just like a mediator, you need to pick the arbitrator who makes sense for that particular case. Not every case fits every arbitrator. But I also, I sort of agree that our jury system is such a good deal that all this arbitration is taking away from that, in my judgment, and it's probably letting people who have more money escape a jury system, which I don't think is a good thing for our system. But once I'm in arbitration, selection of the arbitrator is critical. Don't kid yourself, but depending on who the arbitrator is, the rules of evidence do count. And if you're really smart and can impact the arbitration provision that's in the contract that is being enforced, you want to make sure it includes the notion that the arbitrator it's not a mere confirmation. The arbitrator has to get the law correctly. And that, to me, is a critical thing that a lot of practitioners leave out of the arbitration provision, which shouldn't be left out.
Go ahead,
Go ahead,
Bernard.
Brad. Go ahead.
Well, mine's gonna be real quick because I've been a lawyer 39 years. I just did my first binding arbitration. It was 18 days. It was 18 days long. The judge, the art was a former judge, was really good on the evidence. Didn't just let everything in. Didn't let stuff in that shouldn't come in. I found you get way more done during the day. You don't have the jury. You get a lot of in. We were going 9 to 5:30, and we were getting, probably 2 regular trial days. And I kind of liked it. It wasn't so bad. I got used to like going fast to stuff, but I haven't got the decision yet. So I'll let you know when I get the decision, how the arbitrator was and how the experience was. And I don't like that. You got to wait. I finished this case a couple months ago. I'm waiting for the decision. I've never, well, I have in Federal Tort Claims Act, but usually, they give the decision. The case is over. Boom. You get a decision. Yes or no. Okay. That's what I got on arbitration.
All right, Bernard.
I've had a significant number of arbitrations. I'm not a fan. I don't think it puts the employee on a fair field, and I just think it undermines the jury system and it undermines accountability. In the cases where I've knocked it out of the park, got an arbitration award over $2 million every time, 3 times, that arbitrator stopped being used. And that's an indication that it's not about fair. There's an expectation that you will not give a high award. You're going to split the baby or moderate the number. And that's what arbitration is about. So I'm not a fan. In terms of selection, you've got to be, in all the cases, I'm always looking for corroboration. You need better evidence when you're going to go to arbitration, because there are too many ways that the evidence can be, I'm going to say, undervalued. And you need judges that are going to give it the value that it deserves. Arbitration, I'm going to say the judges are not always keen on the evidence. They figure, I'm going to let it in, I'm figure out what's important, and then I'm going to make a decision. And that's just the nature of the beast. So picking the arbitrator is absolutely important. So bottom line is corroboration. Last thing, the person who's deciding your case is still an individual. You can't try the case as though, I'm going to do the minimum or that. You still got to pull out the stops. They still love impeachment. They still love cross-examination, catching someone in a lie. They still, those are the things that give the case value in front of a jury. Why wouldn't it give the case value in front of an arbitrator? You got to put on the same case and perhaps a better case, because you only got one person to impress. At least you got a couple of jurors can look the other way and not like you, and you can still win. But one arbitrator, you better pull out the stops for him or her.
I will say, Bernard, though, because I've heard your gripe and Genie's gripe on many occasions. At some point, not in this show, I can suggest you should read a couple of opinions I've read from arbitrators who pull out they put more damages on the defendant than God has green apples. So it can happen, but it goes back to your prior point, which is that it matters who your arbitrator is. Don't expect big dollars from certain people, and do expect bigger dollars from other people. It's just as simple as that.
Send me the names of those arbitrators.
Dollar one.
Yeah, I'm gonna end with information about something that I have done for a number of years now. I actually work with a statistician and poll the information that is reported as a result, because it's required to be reported under the CCP, on the various arbitration providers' websites about employment case outcomes. And I have those analyzed. And so I'm talking to you about the actual statistics and the outcomes in employment cases, which are just dramatically lower. I'm talking about, averages in, depending upon the provider, 60,000 to sort of $140,000 range in employment cases, as opposed to seven figures in, jury trials. So it's as stark as it can be. Yeah. And I do report all that too through, SELA and other organizations, because I think it's very important to share that information.
The other thing is arbitrators, there is a track record. It is, I think it's going to be hard to ramrod Brian Panish or Patricia Glasier. If you've got a name, if you've got a recognition, it's going to be harder to screw them. But I have colleagues, people that are younger attorneys that have cases where the judge has decided, made rulings. Judges can put their thumb on justice and make decisions as to what evidence comes in or what have you. And sometimes that happens. And so I'm skeptical about the system, because there are times when I hear stories of young attorneys who are forced into arbitration and have bad results. And I feel like they balance out the results that people with a bigger reputation get.
Thank you for that. Okay, so we're almost out of time, but I want to open it up to all of you for some closing remarks that you may have about the legal profession, or perhaps advice to young attorneys, or any changes that you've noticed since the pandemic with regard to your practice. So if any of you want to speak to any of these subjects or anything else before we leave, and then if we have time, I know a few of you in the audience have asked questions. We'll
I have
try
a
to
quick, Stacie, if I could
Yes.
just I can't believe that I get paid all this money to have such a good time. So unlike Brian, who only enjoys trials, I enjoy every aspect. I love being a counselor. I love trying cases. The whole concept of being a lawyer is exciting. I think the only thing I've seen recently that I'd love to hear what other people's comments are, that I find hugely distasteful, is that I think this horrible word called extortion. You see it more and more, that people are, because reputations are frequently destroyed online. And if people threatening to go to a newspaper about a story is really, really scary stuff. And when you sometimes actually give to opposing counsel, the information you've provided is wrong, let me show you and give you documented evidence to the contrary, they will still persist, because what they want is to extort you or my clients for too much money. So, and I find that to be more today than I did even 5 years ago. And I'd love to see what other people have to say. It's just a shame. That's the negative that I see in our profession today.
I would just echo what the first thing Patty said. To be good, it takes a lot of hard work. And you may not have been on the law review. You may not have been on the moot court team. That doesn't matter. It matters how hard you work. As a lawyer, every day that I've been a lawyer, I've learned, I think, something every day. Now, I only like the trials, Patty. I didn't say I only do them. I have to do all the other stuff too, which there's a lot to it, and managing a law firm and hiring and firing and training. I don't like that part of the practice. And there's much more training for lawyers now, which I think is a good thing. But other thing I would say is watch other lawyers now, because of the pandemic. You have all these video streaming shows, seminars. Watch other lawyers. As a young lawyer, as a law clerk, even when I was in high school, I had to wait for my dad at the courthouse, but I would just watch, and you just learn so much on watching these other lawyers, their different styles. And as Patty and others have said, you got to be yourself. You can't be that person, and they're going to know it. And you have to have passion. And when you're asking the jury, in my case, for a lot of money, if they think there's any hesitation, they're not going to believe it. You have to be 100% passionate and in your case when you're up there doing your final argument, especially on the money. So if they know, if you're just trying to do that, they know. Jurors know 99.9% of the time they're going to get it right, and they know. So just be yourself and work hard. And I will amend what Genie said about a lot of sprints and marathons, and then a marathon with a lot of sprints. I think it's not a marathon, it's a sprint that never ends.
Okay, I'll go with that. Then I'll change it, maybe. Although I don't know. I may stick with mine. That's okay, Brian.
Go read
You
the book
experience it
Winning. The
different.
book Winning, it talks all about that.
Yes. I want to say to lawyers who might be challenged. Sorry, I got a call. But I want to say to lawyers who might not feel great about what they're doing or where they are and might not be happy in their professional lives right now. It's not necessarily the whole profession. You don't have to throw the baby out with the bathwater. It might be where you are and the kind of law that you're doing or which side you're on or what you're not doing. Maybe you don't get enough trial experience. Maybe you aren't being given the opportunity to take the deposition. You worked really, really hard to get a law degree and to get a license. So change your circumstances if you're not happy. And I think you might be able to find a place where you are a Brian Panish or a Patty Glasier who are talking about how much fun they're having and how much they're enjoying their practice. And I know that's true about Bernard as well. So don't give up. Again, persevere. You can find the right place, the right work, and the right side of the V for you.
So when people talk about victories in cases, there's a story that always goes, and it looks like it was the perfect case, but the truth is there are no perfect cases. And I co-counsel a lot of cases, and people bring a case to me, and it always has problems. And people on the back end say, "Why did you ever take that case?" But the whole point is, if I can see a way to get from where I am now to a verdict, if I can explain to the jury how to get there, I'm willing to take that case. And you can't look at cases looking for the perfect case. It's always about what can you do to fix the problems. There's always a solution to the problem or a way to minimize it or put it in context. There's a way. If there's a way to address the problem that can get you there, that is a great case. And so I would say, you have to work hard, as Brian has said, the Kobe approach. If you don't put in the time, if you put in the time, you're going to do well. If you don't put in the time, you're never going to be good. I keep getting better every day, I think. And it's because you keep listening, you keep learning. You can always learn from someone else, and you got to have your eyes open and be listening in order to do that.
Anybody else have comments about case selection?
Corroboration.
Corroborate.
Well, it depends.
Only take good ones.
They have a different perspective than I do. I have existing clients who get sued by their clients, and I appreciate that. So case selection is a much bigger issue, I guess, for somebody who does primarily plaintiff's work, I think.
Yeah.
Than
It is.
Who doesn't.
It's the number one thing that a plaintiff lawyer needs to learn when you're out in your own firm is case selection, because you did a few bad cases and you spend all your time, you're going to be sunk behind them. So I have a rule: when in doubt, kick it out. If you're really thinking, I don't know, maybe not, when in doubt, kick it out.
All right, I like that. Let me take one question from the audience. We have a bunch of them. Somebody has asked us, said that you've all talked about, or most of you, about the importance of civility and having good rapport and relationship with opposing counsel. I see it in mediation too, the importance of that. What advice do you have for those rare instances where no matter how civil, courteous, and professional you are, opposing counsel or the opposing party refuse to reciprocate reciprocate, are not civil, and are not reasonable.
Not about what they do.
But
always
you
gotta
handle
be
that,
yourself.
Patty. Patty can handle that. You must
Okay.
run into some tough guys
gotta
that don't
tell
want to
you.
cooperate.
I had a case in front of a very, very good judge who insisted on civility. The other side, I mean, I've never seen anything quite like it at the time, since I have, where this guy would stand up and he would just lie. And he would call people horrible names. And I decided not to call him in every instance because it wasn't helpful. It was just sort of two lawyers going at it. And he dug his own hole deeper and deeper. But it's sometimes really hard when you know a judge doesn't like the squabbling, and judges don't, no matter what anybody says, they don't like the squabbling. You try to get rid of it as much as possible. And then, in my judgment, you let them hang themselves, because frequently they do, because they can't help themselves at all.
Yep, I
The
agree.
jurors don't like the squabbling either.
When I did a clerkship out of law school, and one of the judges that I was clerking for always said, "Who started the effing pissing match?" That's the way he addressed all of these issues when he was off the bench talking, in chambers. But that is certainly what he was looking for when he was on the bench, is figuring that out. And I don't want to be the person that the judge blames, right? Sometimes we have to be persistent, again, because we need the discovery or whatever it is, but that doesn't mean that I have to be unprofessional. And I know Bernard wanted to say something.
There's a high road. There's a way to do everything. But regardless of what the other side does, you take the high road. Eventually, I'm optimistic. Eventually, things will pan out in your favor.
Thank you, guys. Thank you all so much. Unfortunately, we have to end this program. That's a sad thing to me. I've really enjoyed listening to you all. Thank you all for joining us today. Thank you, amazing panelists.
Stacie, thank you. Stacie,
Thank you
thank
for the
you.
invitation.
Thank you for inviting us all and being with these great lawyers.
Yes.
Thank you, Stacie.
Thank you. Nice seeing everyone.
Thank you
All right.
everyone for this tremendous program. As a reminder, your MCLE certificates will be emailed to you shortly. And until next time, please enjoy the following promotional video that highlights how the world has changed and how ADR Services has changed with it. So please enjoy.
Thank you.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.